So when we talk about courts and judges, a very helpful place to start is with a term you have heard before, but we need to go into in a little bit more detail, the adversary process. The adversary process is used in the United States as well as many other countries to discover the truth through each side, the defense and the prosecution, presenting their version of the law and the truth. We're going to talk separately about the trial, but what we need to recognize over here is in a criminal trial, the state has to present its arguments and its evidence and its legal interpretation, and then the defense has an opportunity for reply. Notice here that the prosecutor represents the state or the people, and that's why sometimes you will hear in court cases a court case being referred to as People versus Jones or People versus Smith. This is a reminder of the fact that the prosecutor is not there representing the victim. The person who is accused is represented by defense counsel, and it's going to be up to the judge to decide the rules of the game or the rules of the court. The judge plays a kind of referee role in most cases. In most trials, the jury is going to decide as to whether the defendant is guilty or not guilty. But there is a kind of case called a bench trial that does not have a jury, where the judge gets to decide whether the person is guilty or not guilty. That situation is reversed when it comes to capital cases or death penalty cases. In the death penalty cases, the jury decides not only whether the person is guilty or not guilty, but also whether they will get a sentence of death or whether they will be sentenced to life in prison, usually without the possibility of parole. A moment ago, I mentioned terms like law and facts, and that's really important because one of the things that structures our court system is which kind of courts deal with facts and which deal with facts and law. Trial courts are courts that engage in the initial controversy in a criminal case. That is when the state charges somebody with a crime and the accused person defends him or herself through their lawyer in most cases. And in that case, the emphasis is on the facts of the case. What does the prosecutor allege happened? What does the defendant reply in return as to the actual facts? But it's mediated and shaped profoundly and fundamentally by law. This might be the law of evidence, for example, regarding what can and cannot be admitted to court. It may deal with laws and rules regarding how a person can be questioned by the two opposing counsel. In contrast with that idea of trials, if a particular defendant is found guilty and is not happy with the verdict in that they believe it is a wrong verdict on legal grounds, that's a critical point, they have certain rights to appeal. Appeal courts almost always only deal with legal issues. So you've probably seen movies where a lawyer will object to something. One of the reasons for that objection might be so that if the judge does not agree with that objection, that lawyer might claim that that is a legal basis to go forward to appeal. In other words, what appeals deal with are arguments that the judge has made some kind of legal error or another, or the prosecutor did not behave properly in some or another way. Now, we cannot use appellate courts in the same way as we can use trial courts. We don't have quite as wide a right to appellate courts. However, we can use appellate courts. In most cases, people don't appeal their cases, firstly, because they're guilty. Secondly, because it's expensive. Thirdly, because they don't have the legal basis for an appeal. So appeals are much less common than trials. And even within appeals, appellate courts only find for the appellant in a small minority of the cases. It's also important to realize when we're talking about appeal courts that when appeal courts find for the defendant, it does not necessarily mean they're getting a get-out-of-jail-free card. The appeal court can do things like order a new trial or order a new trial without certain evidence. It's not simply saying the appellate court found for you, open the prison gates, off you go. In appealing a decision, and asking a higher court to review trial court actions and decisions, one also often gets into broader questions of social change, especially when you're talking about state Supreme Courts and the Supreme Court of the United States. In practice, appellate courts in general and Supreme Courts in particular are agents of social change because some of the decisions they make don't just deal with the individual defendant or individual law enforcement agency, but deal with system-wide changes. So, for example, when we talked about ideas like the exclusionary rule in Mapp versus Ohio, what we see is that led to a system-wide change of greater professionalism in law enforcement. It was much more about whether the prosecutor could use pornography against Mrs. Mapp or not in that individual narrow case. Two of the areas where we think not as being about criminal law, but are about criminal law and are really major examples of social change regard the law coming out of abortion and on gay sex. In the case of Roe versus Wade, the Roe case in 1973 overturned the criminalization of abortion. And in 2003, 30 years later, in a Texas case, the right of states to criminalize gay sex was also found to be unconstitutional. So issues arising out of criminal law can have major social change through the courts. You've just had a chance to have a look at a diagram, and we'll go back to it in a moment. What we see in this diagram is there's both a horizontal and vertical division of courts in the United States. Hopefully you've already got some of the gist of the vertical structure by the mention of trial versus appellate courts. In addition to trial courts of general jurisdiction where you'd have conventional criminal trials, and you'd also have conventional civil trials, but we're not talking about civil law, you can also get trial courts of limited jurisdictions, which deal with the specific kinds of law. They might deal with only misdemeanor cases or particular substantive areas like mental health cases or drug cases, which may involve both the criminal and civil arena. These occur at the state level. Trial courts of general jurisdiction will have jurisdiction over all offenses, including and especially felonies, although the trial courts of limited jurisdictions may be something that individual states will develop in order to deal with particular kinds of cases. The mention of state takes us into our horizontal division in the structure of courts. Something else I hope you have gathered by now is there's going to be a dual court system where you have the coexistence of both state and federal courts. For the most part, states hear the vast majority of criminal cases, something we've mentioned before, and state cases stay within the state realm. However, there are a small minority of cases, Gideon versus Wainwright was one, Mapp versus Ohio was one, where state cases will go to the United States Supreme Court. Again, these are in many ways about policy issues as well as the individual criminal issues and legal issues before the courts in that case. But still, it's going to be state courts that are most traditionally going to be the courts of last resort for the vast majority of cases. Although most criminal cases are dealt with in state courts, increasing numbers of criminal cases are held in the federal system because Congress has made so many more laws that criminalize behavior at a congressional or federal level. Now, the federal system does not have trial courts of limited jurisdiction, and so most criminal cases in the federal system would begin at U.S. district courts. The next layer up in the federal system are the circuit courts of appeals. The whole of the United States is divided up into different circuits, as you can see in the map. And those circuit courts of appeals are the intermediate appellate courts of the system. And as we've already talked about, the United States Supreme Court is the court of last resort, both for the states and for the federal system. Now, for a whole set of reasons, the United States Supreme Court, which we often just refer to as the Supreme Court, which is a little confusing because state courts systems also have Supreme Courts in most cases. But anyway, the United States Supreme Court is tremendously important. And people will often say, oh, I'm going to take this case all the way to the Supreme Court. But actually, that turns out to be a lot more difficult than they might realize. For a start, in order for a case to go to the United States Supreme Court, there has to be a federal question of law. In other words, if the state issue does not raise a federal question, a federal legal question, it's not going to go to the Supreme Court. It's also more likely, especially in criminal law, that it's going to involve a federal constitutional question rather than a legislative question. A next huge barrier for the Supreme Court hearing a case is that it's up to the justices of the Supreme Court as to what cases they hear in the vast majority of the situation. And unlike the rest of us who pretty much have to do what we are told to in our jobs, and pretty much everything that lands on our desk we have to deal with, if you're a justice of the Supreme Court, you can and probably will be rejecting about 95% of the cases that come before you and say, we're not going to hear those. But the Supreme Court is hugely important, in part because its interpretation of the Constitution is definitive in the United States and is the ruling legal interpretation. In other words, you or I might agree or disagree with how the Supreme Court decided something on either moral grounds or on legal grounds. But that doesn't take away from the fact that the law is the law as the Supreme Court interpreted it. Furthermore, because the Constitution has something important called the Supremacy Clause, anything that the Supreme Court rules about the Constitution applies to the whole country. It's not just to the federal government. It applies to the states too. Now, in talking about the Supreme Court, very often you'll hear people talking about the individual justices. They'll also specifically talk about the Chief Justice. Indeed, the court is often referred to by the name of the Chief Justice. So nowadays, and I hope you know this, but if you don't, I'll tell you, the current justice is Chief Justice John Roberts. He was chosen relatively young, so he's likely to be the Chief Justice for quite a while. Before then, it was Chief Justice Rehnquist. And we can go through the different justices in different years. Before then, Chief Justice Berger. Before then, Chief Justice Warren. And so it goes. Both the justices on the Supreme Court and all federal judges are nominated by the President of the United States and approved by the Senate of the United States. They pretty much cannot be fired and have life terms except for extraordinary controversies like being involved in a criminal action themselves. One of the goals of that idea is that judges should have tremendous independence and not make their decisions based on the political ideology of the day, because they're worried about who's going to pay their salaries if they decide one way or another way. Judges, of course, have lots of roles. They are adjudicators, and that's what we see most often, but they also can play administrator roles, negotiator roles, policymaker roles, and so on. But it's that adjudicator role we see most often. And there's a fabulous video you're going to watch that John Oliver has put together about some of the issues about choosing judges at the state level. It's important to remember that different states choose their judge differently. But some of the big issues that cut across the board in most but not all states is that there's an increasing role of money and partisan politics in how state judges are chosen. And state judges can and sometimes do change their rulings depending on the political winds. They would probably deny that, but research evidence certainly gives support to that idea. And here we see some of the difference between the state and federal judges. It's also important to remember that the judges we tend to see in entertainment movies and entertainment TV shows that reflect the vast swath of the United States in terms of age, gender, religion, race, ethnicity, and so on, are also not very reflective of the reality. While the bench, both at a state and federal level, has become more diverse, it is still disproportionately male and middle to upper middle class, and in some cases extremely wealthy. Judges tend to have a strong political connection, even federal judges, and disproportionately to have come from elite law schools. So judges are not among the most diverse in terms of class, race, educational background, and so on, of professions around the United States. However you find a judge, though, defendants, if you find yourself as a defendant, judges are going to make very important decisions at all points of your experience with the criminal justice system. A defendant would see a judge for setting bail, for pre-trial motions. Judges have to accept guilty pleas if there isn't a trial. And of course, as we've already mentioned, they have to referee in trials and decide sentences, except in the case of the death penalty. So judges have very many important roles in the system, both those that we see and those that we don't see that happen behind the scenes.